Namaste. This is Surya Kundeti, and I'm going to give you a lecture from Code of Civil Procedure 1908, and the topic is foreign judgment under the Code of Civil Procedure. So, the general overview of foreign judgment under the Code of Civil Procedure is Section 13 and Section 14. So, this is a general overview. And Section 13 and Section 14 of the Civil Procedure Code establish rules for res judicata in the case of foreign judgments. These provisions adhere to the principles of private international law, allowing an Indian court to recognize and enforce judgments delivered by the foreign court of competent jurisdiction. A foreign judgment operates as a res judicata between the parties unless it fails within the exceptions provided in Section 13. Definition of foreign court. A foreign court is defined as a court situated outside India and not established or continued by the authority of the central government of India. So, definition of foreign judgment. Foreign judgment refers to a judgment delivered by a foreign court. It is an adjudication by the court situated outside India on a matter that falls within its jurisdiction. So, nature and scope of foreign judgments, Section 13 of the CPC, Civil Procedure Code 1908. So, what is this Section 13? It embodies the principles of res judicata in foreign judgment. A foreign judgment rendered by a competent court can be enforced in India provided it does not fall under the exceptions listed in Section 13. So, we will look into these exceptions 13 at a later stage. So, objective of recognizing this foreign judgments is foreign judgments are recognized in India on the principle that when a competent court has adjudicated claim, there is a legal obligation to respect and satisfy that claim because the Indian Constitution respects many other constitutions. That is the greatness of our Indian Constitution. The recognition is not a mere act of courtesy, but is grounded in justice, equity, and a good concise. This principle operates through the Committee of Nations and International Conventions, ensuring that judgments rendered by competent foreign courts are given effect in Indian law. So, we have many examples on this as well, but I can give you a generalized example. A sues B in a foreign court and the suit is dismissed. This foreign judgment will operate as a bar to a fresh suit filed by A against B in India involving the same cause of action. So, jurisdiction of foreign courts. A foreign judgment will only be recognized if the foreign court has jurisdiction in the international sense. Jurisdiction must be established in terms of territorial competence over the subject matter and the parties. So, competence in any other sense, such as a judicial hierarchy, is not a material consideration for Indian courts. Binding nature of foreign judgment, what is this? It has many principles as well. So, a foreign judgment is not binding if the judgment is not pronounced by a court of a competent jurisdiction. The judgment is not based on the merits of the case. The judgment was obtained by fraud. The judgment sustains a claim based on a breach of Indian law. When foreign judgment is not binding, according to Section 13, a foreign judgment is conclusive in the matter adjudicated upon unless it was rendered by a non-competent court, it was not decided on merits, it contradicts the Indian law or international laws, it is against the principles of natural justice, and if it was obtained by fraud, it is based on a breach of Indian law. Presumption as to foreign judgment, it is Section 14. What does this state? Section 14 presumes that a foreign judgment, when produced in a certified copy form, was delivered by a competent court. This presumption holds unless contrary evidence is presented. However, additional conditions for admissibility must be satisfied before such a judgment can be admitted into evidence. Submission to jurisdiction of a foreign court. A foreign court's jurisdiction is recognized when a party voluntarily submits to its jurisdiction. Express submission. Explicit consent by a party to the jurisdiction of the foreign court. And implied submission, we have already discussed this point. When a party through their conduct submits to the jurisdiction of the foreign court. A party that voluntarily submits to the jurisdiction of a foreign court cannot later dispute the jurisdiction if the judgment is adverse. Foreign judgment and res judicata or judicata. A foreign judgment, if delivered by a court having jurisdiction over the matter, will operate as a res judicata between the parties. This means that the issues adjudicated by the foreign court will not be relitigated in India. Conclusiveness of foreign judgment. A foreign judgment is conclusive of any matter adjudicated upon between the parties. It creates a res judicata between the parties and does not apply to strangers to the judgment. So a foreign judgment can only be scrutinized for competence, not for errors of law or fact. Irregularities in judgment. Distinction between jurisdictional errors and irregularities. A lack of jurisdiction by the foreign court renders the judgment a nullity, non-essential, non-exist. An irregular exercise of jurisdiction results in an irregular but valid judgment which cannot be disregarded. So judgment and the reasons, what are these? The foreign judgment is conclusive but does not include the reasons given by the foreign court for its decision. If no reasons are recorded by the foreign judge, the judgment can still be enforced, but the reasons are not part of the judgment's enforceability. So, effect of a foreign judgment, what does it state? A foreign judgment is conclusive as to the matters adjudicated between the same parties. It creates a res judicata between the same parties or those claiming through them, preventing relitigation on the same issues. Doctrine of merger. The doctrine of merger does not apply to foreign judgments. A party may still bring an action in India despite having won a case in foreign court, as judgment does not merge with the cause of action. Enforcement of foreign judgments in India. A foreign judgment which is conclusive under section 13 can be enforced in India through filing a fresh suit based on foreign judgment or an execution petition. Proceedings as per the Indian law only. So what is this foreign award? A foreign arbitral award can be enforced in India under the Arbitration and Conciliation Act 1996. If the award is enforceable in the country where it was made, it can also be enforced in India. There is a detailed explanation in the Arbitration and Conciliation Act 1996 on this point, and we shall discuss this arbitration point at a later stage. Execution of foreign judgment. A foreign judgment which is not covered by the exceptions in section 13 Civil Procedure Code 1908 may be enforced in India through execution proceedings. The procedure for execution is similar to enforcing domestic judgments, provided the foreign judgment meets the requirements of recognition under the Indian law. So, apart from this foreign judgments, we also have one more important point called as the place of suing under the Code of Civil Procedure, which is very, very important. And under this, we shall discuss the general concept of this place of suing. What does it say? Meaning, place of suing refers to the form and venue where a civil suit must be instituted. It includes rules for determining the proper court, that is in terms of pecuniary and territorial jurisdiction, which we have discussed in our earlier class, the nature of the suit and its subject matter. So, types of suits. So, suits relating to immovable property, compensation for wrongs, other civil disputes. So, scheme of sections, Civil Procedure Code. Section, subject matters, and subject matter is section 15. So, what does it say? Suit to be filed in the court of lowest grade competent to try it. Section 16, what does it say? Suits relating to immovable property. Section 17, suits where immovable property is situated in jurisdiction of multiple courts. And section 18 says a procedure when jurisdiction is uncertain. And section 19 says suits for compensation for wrongs to person or movables. Section 20, other suits, it is a general provision. And section 21 says objections to jurisdiction, which is a territorial and pecuniary. Pecuniary jurisdiction, what are these general principle is every suit shall be instituted in the court of lowest grade competent to try it. And what is the nature and scope of the suit? A decree passed by a court having higher pecuniary jurisdiction is not a nullity. Such courts retain jurisdiction to try the suit. What is the objective? To prevent overburdening of the higher courts, provide convenience to parties and witness, and a mode of valuation is determined based on plaintiff's averments in the plaint or the complainant or the notice. The context and the cause of action is also very, very important. So what are the powers and duties of the court? Once the court is seized of the matter, it does not lose jurisdiction if the amount ultimately ascertained exceeds its pecuniary limits. So, however, conflicting views exist on this point also, but so all those things, all those points can always be understood that to prevail the justice, they are all considered. So, territorial jurisdiction. Territorial jurisdiction is very, very important when it comes to districts or states and also center as well. Classification by nature of suit. Immovable property section 16 to 18 falls under this territorial jurisdiction. Suits to be instituted where property is situated, including suits for recovery or possession or partition or mortgage, sale, redemption, determination of rights or interest. Torts to immovable property does apply to it. So what is movable property according to section 19 of the Code of Civil Procedure? Movables follow the person also. Suits may be filed where the wrong was committed or where the defendant resides or carries on business. Compensation for wrong, section 19. Plaintiff has option to file where the wrong was committed or where the defendant resides or works for gain. What are the other suits? Section 20. Suit to be filed where defendant resides or cause of action arises wholly or in part or where defendant carries on business or works for gain. Selection of forum. Consent cannot confer jurisdiction where none exists by law. Parties cannot use the jurisdiction of a court by mutual agreement if the court is otherwise competent. So, jurisdiction as to subject matter. This is very, very important point. And inherent lack of jurisdiction over subject matter renders any decree, order or judgment a nullity. You can't go to an taxation court for divorce or something like that. So, it is just only an example. Subject matter jurisdiction is essential and non-viable. And we have a forum shopping as well. Litigants should not approach a court merely because they expect a favorable order from it, especially where a jurisdiction is absent. So, objections to jurisdiction can be read in section 21. General rule is that a decree passed by a court without jurisdiction is void. However, the principle does not apply to territorial jurisdiction or pecuniary jurisdiction unless certain conditions are met. So what is the object of this? The object is to protect honest litigants and prevent harassment through technical objections. Objection to territorial jurisdiction, what is this? Allowed only if raised in the court for first instance or at the first instance or on the first day of listing the case, at the earliest opportunity before or settlement of the issues, and there has been failure of justice also. At these points, you can object for the territorial jurisdiction. And objection to pecuniary jurisdiction. Court considers the plaintiff's valuation in the plaint allowed only if raised at first instance at the earliest possible opportunity and there has been consequent failure of justice. Objection as to subject matter jurisdiction. It is a non-negotiable, means no court can decide a case beyond its defined subject matter jurisdiction. Any decree or order is a nullity. Application to execution proceeding, section 21, subsection 3. The principles in section 21 apply equally to section execution proceedings. Execution proceedings and the jurisdiction also varies. There are some rules as well. Pre-amendment position. It means that before 1976, so what are the conditions? Section 21 did not apply to execution proceeding before 1976. Supreme Court in one of the famous cases called as Hiraral versus Kalinath, as per the All India Record 1962, Supreme Court 199, applied its principles judicially. Post-amendment position, what happened to this applicability of pecuniary jurisdiction after 1976? The 1976 amendment expressly applies section 21 to execution proceedings. Objections to territorial jurisdiction and execution proceedings are restricted unless conditions are met. So we have one more important point which is called as bar of suit. No objection to the place of suing may be taken at the appellate or revisional stage for the first time, though a separate suit seeking to set aside a decree or jurisdictional grounds. The principle also applies mutat and mutandis to pecuniary defects. So what are these? These are set by general principles or consolidated summary. A suit must be instituted in the lowest grade court competent to try it according to section 15. No objection to territorial or pecuniary jurisdiction shall be entertained on appeal or revision unless the objection was raised at the earliest opportunity and there was a failure of justice. No suit shall be set aside a decree based on territorial jurisdiction defect alone. So, I hope you really like this grounds on jurisdiction or topics which I have discussed just right now. This is just as said before in my earlier classes that I am doing these classes for a charity for an organization by name ABC Charitable Trust, and whatever the donations you make for this class will be spent for educational and school children purposes for their nutritional benefits. And the name of the organization is ABC Trust, and you can make a small donation of 59 rupees if you like this class to the UPI number 9949398998. Just rupees 59 will make a huge difference to the charitable organization. The QR code is going to be shared at the end of this video for your convenience, for your scanning using UPI, and I hope you will definitely make some contributions to the charitable organizations. This will also help me to make more lectures on the law on the same topic, Civil Procedure Code. It was very nice making this lecture class, and thank you. I hope you liked it, and thank you. Namaste.